Hello again, this is LA Dan. Tyra, Jailbird, more. Tyra, I watched you in court today, and they read off the charge to you, intimidation. And they also have a restraining order against you against two people. Congratulations, my man. You finally hit the big top. Kinda. But regardless, you've lost all gun rights, Mr. Law Professor. Know all the laws and nobody told you. Again, Mr. Scholar, let me reiterate, as a legal law scholar, you should have already known that. You don't have to be convicted. But anyway, moving on. Then you go live after your court hearing, after you change some channels' names around, and you talk about the intimidation charge, except that you only talk about the first part of the intimidation charge. You don't talk about the other part of why. And I will read the part 2, and the part 2 states that another person be placed in fear of retaliation for a prior lawful act. Now again, Tyra, it said prior. Now they was at your house. They don't deny that. But when did they threaten you? Because that's what you're claiming, is that they threatened you and they never spoke to you, going on everything that you've said. But you did take it and make a video and send it to them of you threatening them. And then you want to say, well, I don't know who they are in court. So you said that wouldn't be a problem. Again, you have the restraining order, which still means that you can't have guns. And you knew that even at the beginning, that you had the restraining order, even though you didn't know who it was against. But you do now, and you still don't know them. So how did they threaten you? But you did threaten them. And then you want to talk about this, and to you, it is a huge criminal case. And you want to bring all these people in, and you want to take it and question them. Again, the court, I'm pretty certain, is going to disallow it because it's irrelevant. You can't bring in relevancy. Just because all that stuff may or may not have happened to you, it's irrelevant to the court case against these two gentlemen. Now, after you're convicted, you might be able to take it and bring them in, but not during the court proceedings, that you're so bound and determined to take to trial. And then you want to say, well, I haven't had any criminal convictions and anything like that. Well, if you take it to trial, again, once they find you guilty of intimidation, of the felony, you're going to do the 2.5 years. And they cannot lower or change it after you are convicted of it. And as a legal scholar, you should know that, Tyra. It doesn't work that way. There are plenty of people that commit crimes that's never had any kind of interactions with the police at all and been convicted. And it doesn't change the fact. And they don't get it changed. All it says is that, you've been a good boy and you might get less time. That's all that means. Maybe. So, anyway, hit the like, hit the subscribe, and as always, leave a comment. This is LA Den, signing out.